Hi, I'm Dan Kuperstein, and welcome to this episode of Compliance Minute. On December 31st, 2015, a federal trial court in Wisconsin rejected the EEOC's challenge to an employer's wellness program, holding in EEOC v. Flambeau that the wellness program was protected by the bona fide benefit plan safe harbor provision of the Americans with Disabilities Act, or ADA. That ADA safe harbor had been considered to be on its way to extinction after the EEOC released proposed rules in April of 2015 that had stated in the preamble to those rules that the safe harbor should no longer be applicable. Let's discuss the key facts of the case. The EEOC, on behalf of the employee, had sued the employer after the employer terminated the employee's coverage under the employer's self-insured health plan, when the employee failed to complete the wellness plan's programs in a timely manner. Enrollment in the employer's group health plan was conditioned on participation in the wellness program's health risk assessment, or HRA, which included a medical history questionnaire and a biometric screening. While the ADA generally prohibits employers from requiring their employees to submit to medical examinations by conditioning participation in their health plans on completing HRAs, biometric screenings, and similar tests, the employer claimed that 1, its wellness program was used to identify health risks and was for underwriting purposes, and therefore was permitted under the ADA's bona fide benefit plan safe harbor, which exempts, quote, the terms of a bona fide benefit plan that are based on underwriting risks, clarifying risks, or administering such risks, unquote. The employer also argued that 2, the examinations were required only if an employee wanted to participate in its health plan, and as such were permitted under the ADA's exception for, quote, voluntary employee health programs. Ruling in favor of the employer, the court held that the ADA's bona fide benefit plan safe harbor permitted the employer's plan to include otherwise prohibited medical examinations as a condition of enrollment. The court also held that, in light of this conclusion, it was unnecessary to determine whether the medical examinations were required or voluntary under the ADA. In reaching these conclusions, the court relied on an earlier decision, Seff v. Broward County, which had upheld the application of the bona fide benefit plan safe harbor to a wellness plan. The court also concluded that even if it were bound by the EEOC's recently proposed regulations on voluntary wellness programs, the proposed regulations only address wellness program incentives and say nothing about the safe harbor's application to wellness programs such as the one at issue, which was used to administer and underwrite insurance risks associated with the employer's health plan. While not addressed in the text of the proposed regulations, the EEOC stated in the preamble to the proposed regulations that, quote, the EEOC does not believe that the ADA's bona fide benefit plan safe harbor, as interpreted in Seff v. Broward County, is the proper basis for finding wellness program incentives permissible. The court's holding in Flambeau greatly undermines the EEOC's position on ADA-compliant wellness plans. And if never challenged by the EEOC, it would give employers great leeway in establishing HRAs and other medical examinations that can act as a sort of gatekeeper to the benefits of employer-sponsored health plans. Finally, because of that language in the EEOC's preamble to the proposed regulations, it is very likely that the EEOC will appeal this decision or alternatively address this issue in final regulations, which are expected to be released soon. For more information on this and other topics, please visit our Knowledge Center at corpsyn.com. Thank you.